Welcome back. The Madras bench of Madras High Court has now called for legislation regulating internet usage by children in India. The court observed that with rising concerns over social media misuse, India must act to protect its young users. The court has asked state governments to prepare an action plan to spread awareness on child rights and safe internet practices until such a law is framed. The big question now is, will India follow, for example, Australia's policy of banning social media for children under the age of 16. My colleague Mugilan is also joining us with more. Mugilan, first up, break down what all has been the observations or the contentions of the Madras High Court.
Now we are seeing the Madras bench of the Madras High Court coming up with very important observations regarding the internet usage among the minors, particularly the kids who are below age of 16, and they owning the social media accounts. So when this petition was taken up for hearing yesterday, the bench, Madurai bench headed by Justice Jayachandran, has suggested the central government to come up with a legislation like how it is in Australia, that is the minors who are below the age of 16 cannot have a social media account. And the chief and the court also have asked the Tamil Nadu Commission for Children's Safety to come up with an awareness drive among the minors against the ill usage of internet, and it has also stated that it should take up the work immediately. So now this petition was seeking a parental window as parental window for the minors to use the internet, because the petitioner has stated the explicit content are very easily accessible and available on the internet for the minors to access. So there should be a parental window. So this was the petitioner's request, and this was taken up for hearing. So we have to wait and watch what the central government will reply to the observations made by the Madurai bench of the Madras High Court. But now the Madurai bench have suggested that the central government should come up with a regulation like how it is in Australia, preventing minors from accessing social media accounts and owning social media accounts to surf online.
This is, of course, a suggestion or a request that has come in from the council in this case as well, who also said that in view of proportion of pornographic content easily available to children today, that above relief is needed, that the Commission has a statutory duty and responsibility to spread child right literacy amongst various sections of society. But prominently, this suggestion that India should follow what has happened in Australia has come from the petitioners as well. What was their main contention? Was it asking for this ban, or can you expand on that parental window that they were asking for?
The petitioner was very specific on the parental window, that is to restrict the access to the explicit or the pornographic content by the minors. So it was the observation of the Madurai bench of the Madras High Court was cited, which was cited the Australia government restriction was the observation made by the Madurai bench, and it was not made by the petitioner. So the Madurai bench have cited it as an example to come up with a similar legislation. So we have to wait and watch what the central government will be replying in this matter.